SJC-10241, Commonwealth versus Lee.
Ms. Peterson, good morning.
May it please the court. Good morning, Your Honors. Jennifer Peterson on behalf of Mr. Tom Lee. If I may, Your Honors, I'd like to begin by addressing my first argument raised in my brief, which is that the trial court erred in allowing the Commonwealth to impeach Mr. Lee's testimony with uncounseled statements that he was alleged to have given to the police.
Okay, I have a question. I've read part of the transcript in this case. Why did the judge find that the statements were involuntary? The officer said she gave him the warnings orally, and she said she gave him a form. I know the judge seems to have been piqued that the Commonwealth hadn't turned over the form in advance, and there's a question, at least in my mind, whether they were obligated to. But even aside, if they can't put the form itself in evidence, they could still testify that they gave him the form. That's routine. So what basis was there for the judge's finding that the statements were involuntary?
Well, Your Honor, defense counsel raised three different objections. One was that there was the violation of the discovery contract. But
okay, but that doesn't make the statements not voluntary.
Yes, Your Honor. Yes, Your Honor. He raised, defense counsel also raised the fact that Miranda requirements weren't met and the involuntariness.
But how were the Miranda requirements not met?
Well, there was a voir dire of Police Officer Buglio, and in the voir dire, she went over what she told Mr. Lee, who, it bears stating, is English is his second language. He's a native Vietnamese speaker. And she went over what she said to him, and even in that recitation, there were portions that were incomplete, including the fact that the statements that he used, that anything he said could be used against him in a court of law.
She omitted to give that?
Excuse me?
In her recitation. In her recitation in court, she didn't give that?
Yes, Your Honor.
Okay, yeah.
She neglected to give that.
Okay.
The Miranda, I would suggest, Your Honors, is just one of the factors that the trial judge could have considered in deciding that the statements weren't voluntary. The non-native English speaker was another factor. The fact that Mr. Lee was unexpectedly arrested at his place of employment, taken into custody, brought to the police station for questioning. This is a man who's not particularly experienced with the judicial system. He was in a small room with two uniformed officers asking questions, and those factors were all in addition to the Miranda problems. So I would suggest, Your Honors, that the judge was well within his discretion in finding that the statements Mr. Lee gave to the police officers were involuntary.
What was the timing of that decision? Was it after the jury had been chosen?
Excuse me, I didn't hear the question.
What was the timing of the hearing? Was it after the jury had been chosen?
Yes, Your Honor. The case was in session. The Commonwealth called two witnesses, the first being the complainant and the second being Officer Buglio, who testified not only as the arresting officer but as a fresh complaint. King hadn't been decided yet. As a fresh complaint witness, when the Commonwealth sought to use Mr. Lee's statements against him substantively and bring it in with Officer Buglio's direct testimony, that's when defense counsel objected. The jurors were excused, there was a voir dire held, and arguments were made, and the court ruled that Miranda requirements were not met and that the statements were not voluntary.
Isn't part of the problem that that defense counsel didn't bring the motion before trial and therefore was left with the uncertainty of what the single justice would do with regard to the appeal?
Yes, Your Honor, I would suggest that that is a problem. However, while there were statements made and there was no suppression motion, there was not. Defense counsel stated at trial that he never received any sort of Miranda form, and so.
But did he have police reports?
The police report referenced. There were statements referenced in the police report. The police report referenced that Mr. Lee, Miranda rights were told to him, and that he stated and signed that he understood them. So from stated and signed in a fairly lengthy police report, the defense counsel would have had to tease out that there may be somewhere out there a Miranda.
Did he go over his statements in the police report?
Yes, there were statements in the police report, and no suppression
And it
motion
said
was
that the
filed.
defendant signed, so he had to have signed something regarding Miranda.
Yes, well, yes, Your Honor, one would assume
One
so.
would think it was a waiver of Miranda. I don't know what else it could be if he signed a form about Miranda.
Perhaps, but there's an argument that, and the judge agrees, that defense counsel isn't within his rights raising that issue at trial.
What, that he didn't get the form? Why didn't he ask for it before trial?
Not
He
not
knew
about the form, not about the form, Your Honor, that there was, that this was an acceptable time to object to the admission of these statements.
And what are we, that's an acceptable time. What are we supposed to do with the jury that's sitting there?
The jury wasn't sitting there during argument of counsel.
Well, that's right. The jury is out, and we're wasting the precious juror's time because the motion hasn't been brought ahead of time.
And we're here now, Your Honor.
Well, because the motion wasn't brought ahead of time, which is under the rules when it should be.
Perhaps that would have solved this problem.
Well, I have another question. When the
Yes.
defendant testified, the Commonwealth had already said that it was taking a 211-3. Is that correct? So the
Yes.
defendant knew, any defendant knows, any ruling subject, or any defense counsel knows, any ruling during trial, Commonwealth could go up any time on a 211-3. But in this case, there's no question counsel knew because the Commonwealth had announced that they were going up and trying to get the judge reversed.
Yes, and in fact, the Commonwealth requested
Right.
Judge Garth stay the trial at that point, and Judge said no.
So
The Commonwealth had no
defendant-
further witnesses,
So the defendant, when he testified, was testifying at a known risk that the judge's ruling would be reversed.
Well, certainly, but it's that or give up your right to testify on
Or
your own
ask the-
behalf in
Or
general.
join in the motion to stay the trial. Maybe it would be to the defendant's advantage to have joined in the motion.
Perhaps, and there's an ineffective assistance of counsel argument made in the brief.
Which judge are we reviewing?
I would suggest both, Your Honor. I think the trial court made the correct decision in Mr. Lee's opinion.
So then the single justice made the wrong decision.
The single
Made
justice
error.
the single justice stated that the statements could be used if permissible. And I would suggest that's not error. I would suggest that goes back to the trial judge, because I would suggest that it wasn't permissible in the circumstances of this particular case that those statements be used. And I would point, at this point, to Harris versus New York and Commonwealth versus Harris. Even if we assume, for the sake of argument, that the single justice was correct in vacating the lower court's finding of voluntariness, I think we need to look at Harris and say that Harris is a similar case to this, in that, both of the Harrises actually, in that they involve the admissibility for impeachment purposes of defendant's statements that were obtained in violation of Miranda safeguards. But both of the Harris cases are different from this case, in that the statements that were looked at were statements which didn't tend to prove an element of the crime. They were collateral to the elements of the crime. And the problem here is, and Your Honors touched upon it in a case that I don't cite in my brief, that I've mentioned to the Commonwealth today, a case called Commonwealth versus Feeney, F-I-N-I, which is at 403 Mass 567. And it's a 1988 case, and on pages 570 to 571, this honorable court discusses this particular issue, which is that in situations where you're only using it to prove a collateral issue, you're warranted, the balancing act is warranted in saying, we're going to balance taking care of making sure that the police aren't committing misconduct with a defendant not being permitted to use exclusionary rule to commit perjury. That's a very delicate balance, and I think that's what the Harris case tries to do. I would suggest respectfully, Your Honors, that this is a case where the balance is tipped in the defendant's favor because the statements that the Commonwealth sought to use against Mr. Lee it was the issue. It went to the heart of the case to be decided against him, which is the issue of consent. And what the police officer testified to, and the statement that this is really all about, which is on 388 of the transcript, he stated, the complainant had stated to him that while he was penetrating her to stop, that the complainant stated to stop. The complainant stated on several occasions, yes. That's the issue jurors were to decide. This is the third time this officer had taken the stand on behalf of the Commonwealth.
When you say third time, because it was called in rebuttal and then called again on rebuttal?
Yes, Your Honor, because just as the defense counsel started to cross-examine her, the SJC stayed the case. So the case was stayed until the next day. So this is the third time jurors got to see this police officer testify against Mr. Lee. This is a girlfriend-boyfriend rape case that was downgraded to indecent assault and battery. And
What is a booty call, please?
a booty call, a call for sex, Your Honor.
Sorry?
What, in the defendant's examination, did he not say that she said stop only when he was speaking about the likelihood of ejaculation?
Yes, I mean, I think the parties testified fairly consistently with respect to everything except the timing of the request of the complainant to stop. He said in his testimony that she said it more than once and up to 6 times to stop, but that she said it subsequent to his saying to her that he was about to ejaculate. And she did that. What it was in reference to is, please don't do this inside of me, and he respected that wish. She, of course, testified that no, when she said stop, that what it meant was stop penetrating me, not don't ejaculate inside of me.
But wouldn't the Harris case permit him, the government, to admit a contradictory statements made during his police statement?
Your Honor, I would
that
suggest...
That she had said stop numerous times and not simply at that point in the intercourse?
No, and that's the point I was getting to. That's the point that I just raised, and I think Feedy talks about it more eloquently than I can here, which is that would tip the balance because we're no longer talking about a collateral issue, impeaching a defendant with a collateral issue. We're talking about the heart of the case that jurors are to decide. So really there's just too much danger in these circumstances that jurors, even properly instructed as these jurors were, that you would use a piece of evidence like that as substantive proof of Mr. Lee's guilt.
So it's okay to perjure yourself without fear of cross-examination with a Miranda statement as long as it's on a critical point in the case?
Your Honor, I don't think it's ever okay to perjure yourself, but I think in situations such as these, we need to tip the balance in favor of a criminal defendant, because to do otherwise, you're so fettering the right of a criminal defendant to testify on his own behalf is to make it impossible. So if this court's ruling is that the Commonwealth can impeach with testimony statements that were obtained in violation of Miranda principles, but were voluntary, were deemed to be voluntary statements, then you're saying that the police should be, I mean, the Commonwealth should be able to admit testimony as to the elements of the crime. And I would respectfully suggest, Your Honors, that Article 14 gives you gives broader coverage when a statement goes to the heart of the matter and not just collateral.
I thought your argument was more narrow than that, or maybe it's an alternate argument. I thought your argument was, regardless of whether one might have been able to, Commonwealth could have done that in the first instance, the problem here was it wasn't known until after the defendant testified that that was going to be an option because of the timing of the going up to the single justice. I mean, I thought it was on the particular in the particular facts of this case where the defendant has testified in a situation believing that he can testify, and it isn't until afterwards that he is informed now this may be used against you.
Yes, Your Honor.
And that's different than what you're just saying now.
Yeah, I believe it's all there, and I think first I would point the court to the fact that the lower court, I believe, was right in saying that these statements were involuntary and they shouldn't be used at all. Second, I would say that Mr. Lee had a right to rely upon the judge's ruling that these statements weren't coming in. They weren't coming in for any purpose. The judge said it several times during the course of this trial. The judge did an about-face when there was a language issue toward the middle of the trial, as far as whether or not Mr. Lee had met with the police officers. It seemed to be confusing. That seemed to be clarified by defense counsel, but still they brought the officer back to impeach him. And then, finally, when the SJC single justice ruling came down, the judge said, okay, go ahead, you can impeach Mr. Lee substantively. And I would say that first and foremost, the judge was right, that it was involuntary.
Can I ask you,
Yes.
I know your time is up, but
Yes.
it's on my mind and I need to ask. The phone records, did defense counsel have the defendant's phone records and simply neglect to cross-examine the complainant on them?
That's my understanding, that he had him. He failed to call the keeper of the record, and he failed to cross-examine her. He tried to
Well,
recall.
he wouldn't have to call the keeper of the record to cross-examine her if you had the records.
He neglected to do it, and he requested that the judge allow him to recall the complainant, and the court said no.
Was there evidence that there had been contact, nevertheless, between the defendant and the victim after the incident?
She denied it, didn't she?
She denied it, and he said that there was a whole series of contacts.
Did she say that there had been who put in the evidence about the email?
There was one email. I believe she may have.
She didn't
did
deny
one
it
email.
totally. She said there was an email.
One email.
And she said that her friend had contacted him or something also.
Yes, but that she denied any other
But
contact.
there was evidence of contact,
well,
just from her.
I take it that the issue here is credibility, and if in fact those records had shown that she had called on a number of occasions in the day following or in the days following, that would be a serious blow to her credibility since she denied doing that.
Yes, which is exactly why we said in the motion for a new trial.
You didn't attach any records to that motion, at least as far as I could see, did you?
I wasn't the motion
Are
judge.
there records attached to the motion for new trial?
There are 2 affidavits attached. There are not phone records
Did I read
attached.
somewhere that they had been destroyed, the records?
Excuse me, Your Honor?
Did I read somewhere that the records had been destroyed?
I recall that they had, there was some,
Yes, so my
something.
question is what records? Because, I'm confused, as is Justice Cordy, because I believe that I read somewhere that the records had been destroyed, so there were no records to be called.
I believe the records that have been destroyed, quote unquote, they have been erased off of Mr. Lee's cell phone, not that the actual statements had been destroyed.
I see.
So that he was unable to prove with the actual cell phone. That's my understanding, Your Honor.
Thank you, Ms. Peterson.
Thank you, Your Honors.
Good morning, Ms. Eisenhower.
Good morning, Rachel Eisenhower for the Commonwealth. I'd just like to start by addressing your factual issues. The email was not put in through the victim, it was put in through the defendant. The Commonwealth was told that they could not put it in substantively, but the judge said, you can refresh recollection with whatever you want. If you want to show that piece of paper to the defendant and see what he says, go ahead. The defendant then adopted, said, yes, I wrote this email. At that point, it became an adoptive admission, and the judge allowed it in for its full evidentiary weight.
So this was an email sent by the defendant?
By the defendant to the victim. There was testimony that it was in response to an initial email from the victim, but that initial email was not in evidence.
All right, but let's go. I don't want to distract you
Was it
from...
ever produced in any way?
I've never seen it.
So the answer is no. So for all we know, he just sent this email.
For all
As
we know.
far as the record exists, he sent an email. There's no evidence that she sent an email.
I believe his testimony says it was in response.
I understand.
Oh.
Other than the defendant.
Other than the defendant's testimony that it was in response, all we know is that he sent the email.
Okay.
I don't want to distract you from the first issue, but since you've started with this, Do you understand what happened here with respect to these phone records? Did the defense counsel essentially want to recall the witness so he could cross-examine her with the phone records that he had?
I reread the transcript last night. My understanding from the sidebar conversations is that when the complainant finished her testimony, the defendant approached his counsel and said, she's lying. The next morning, he came in with his own phone bill, not an official record of the company, but the bill that they sent to him, handed it to counsel and said, see, this is her phone number. At that point, he attempted, the first time he showed it to counsel for the Commonwealth was immediately before he attempted to cross-examine the witness on it. Then the judge didn't.
So
And then
wasn't
the
it
judge
error?
then
Wasn't it error?
Justice Cordy, just hold on. Then the judge didn't let it in, or
My recollection is that the judge didn't let it in. He said that's hearsay.
Well, I'm sorry, but I thought the defense counsel wanted to recall the complainant here to essentially cross-examine her.
Yes, you're right. You're right, Your Honor. She was no longer on the
Isn't
stand.
it true that you called on this date and this time? Is this your phone number? I mean, that would be permissible cross-examination.
That is what had happened. I'm not sure who was on the stand when he initially pulled out the record, but it was not the complainant because he was not allowed to cross-examine her. So I would conclude, therefore, that it was the defendant on the stand when he pulled it out. But I do know that it was that second day that defense counsel had not had this prior to trial either, is my understanding from the record.
defense counsel had not had the telephone records?
No, it was handed to him by the defendant. What I gather from the transcript between sidebars and testimony is that the defendant had a cell phone which was shut off. He represented to counsel that the victim had been calling him and leaving him messages. Counsel said, save those, and then they disappeared. The voicemails disappeared when the phone was shut off. There were no official...
You mean it was shut off for non-payment or something?
Presumably. I don't believe the word non-payment is actually
he
in the
didn't
record.
turn it off.
No, he didn't cancel his phone bill. The phone company canceled his service, presumably for non-payment.
I take it that it is preserved, the objection to the fact that he was not permitted to recall the complainant now that he had additional ammunition to cross-examine.
I believe he did object to that and preserve that.
So why isn't that error in the circumstances of this case?
Well, because it's a collateral matter. It doesn't go to what actually happened in the bedroom on the evening. It does go to credibility, but this is not purely a he said, she said case. This is what he says at trial on one side, and on the other hand, what she says at trial, supported by an email from him apologizing and saying, I see why you're mad now, which the jury could infer is an acknowledgement of guilt. So his own acknowledgement of guilt, I would say, cures any prejudice from not being allowed to cross-examine the witness. And again, it's the credibility on the phone records is after the incident, so I'm not sure that even without that difference, it would.
Was there evidence that they remained friends after, and did they?
The defendant's testimony was that he cut off contact with her because he didn't feel safe with the pending charges having contact with her. Her testimony was she never contacted him again, but friends of hers did, which would also be a possible explanation if they used her cell phone of the records. So it was unclear.
Eisenhower, again, we can but if it's a constitutional right, denial of the right to cross-examination, and it's a preserved error, I mean, that's a pretty high standard to overcome.
Well, it is, Your Honor. But under the circumstances of the case, where his an admission in the evidentiary sense, his email supported the complainant's testimony, I don't think that the result would have changed based on the inability to cross-examine. Furthermore, it was not
would a jury not wonder why there are multiple telephone calls? In other words, there are all kinds of reasons one could argue why somebody might apologize to say, I can understand why you're so angry with me. It would seem, at least on the surface, that if there's a claim of rape, total consent, what is the victim doing contacting, if in fact she did? And wouldn't the jury need to know that?
That would certainly be interesting, but individuals do all kinds of things. I mean, they're especially
including sending emails saying, I can understand why you're angry with me.
Well, in a date rape situation, I'm not sure that the victim attempting to contact the defendant is actually inconsistent with her testimony. I think that often...
Oh, and also in a date rape situation, it is not inconceivable that somebody might apologize.
It is not
or to say,
inconceivable.
I understand why you are angry with me.
I don't have the text of the email in front of me, but I would refer you to the text of the email before you determine whether it would be interpreted that way by the jury. The other thing about the phone records is he could still have cross-examined her about the phone calls based on his own conversations with the defendant, even if he had not had that document at that time.
He in that sentence is defense counsel.
Yes, I'm sorry,
Sure.
defense counsel.
No, that's okay.
You know, partaking of the great attorney-client privilege at counsel table, could have had some sort of whispered conversation and said, "But isn't it true?" And then she would have denied it.
But I think your memory is going to be better about this than mine. But I thought I read in the transcript that defense counsel actually did ask her that, and she did deny it. Am I wrong about that?
She may well have, but
But then you have telephone records that come from her number to him.
Which Judge Garth ruled were hearsay and inadmissible. So the only thing he would have been able to do with them under that ruling is refresh her recollection. If she had continued to deny it, then it would have remained unchanged.
But we all know the great cross-examination of the holding up of the documents, right?
Of course, Your Honor. I would like to address the first issue, and of course that's, you know, the complainant's version is also buttressed by the prior inconsistent statement of the defendant to the police that came in through Officer Buglio, of course. But on the first issue of who are we reviewing, my understanding was that usually the procedure for reviewing a single justice order is an appeal to the full bench through Rule 221. This is not arriving here through that method. That doesn't necessarily solve the issue, but it's interesting.
If you slip away all of the procedural routes that it got here, one way to think of it is, in essence, it's not dissimilar from a case that is here on further appellate review, which is we don't review the appeals court, we review what happened in the trial court.
Yes.
And that's one way to look at it. In other words, we're not doing it under the classic error of law 211.3.
Absolutely, Your Honor. But
in other words, if Justice Graney had ruled against the Commonwealth and the Commonwealth had sought an immediate appeal, that would be a very different situation.
Yes.
I'm not sure it makes that much of a difference here, does it?
No, I don't think so.
Okay.
But in any case, the current law of the case is that order by Judge Graney, is that it is a Miranda violation, but voluntary. And that's the current law of the case, is that this is a voluntary statement and thus admitted. The if permissible reference in Judge Graney's order, I read as simply a reference to the law of evidence, that the trial judge must find that this is a prior inconsistent statement before he allows impeachment on the matter. And whether it is a prior inconsistent statement would be unknown to Judge Graney because he didn't know what the defendant testified. So that's all the import I read in the words if permissible.
And that would certainly be consistent with an interpretation where somebody is saying this shouldn't come in because it's not voluntary, right? And Justice Graney says no, it can come in, but there may be some other constraints that aren't raised in this appeal.
Precisely.
Okay.
One of those other constraints was the discovery issue. The judge decided that he was displeased with the failure to produce the Miranda card, and he decided that therefore this was de jure unmirandized and would be excluded from the substantive evidence. But Judge Graney reversed the voluntariness portion of the ruling and decided it was voluntary, and then impeachment was allowed with this. Are there any questions on the first issue? Are there any questions on either the mistrial, ineffective?
You get to argue whatever you want to argue.
Okay.
We'll interrupt you, I can assure you.
Okay.
Yeah, I've actually got a question. We have a claim of counsel being ineffective.
Yeah.
We have a counsel who apparently, in a date rape case, did not make inquiry of his client or obtain the telephone records that would have revealed communications maybe between the client and the alleged victim after the event. We have a defense counsel who failed to move to suppress the statement of the client in advance of trial.
Yes.
What should we do with all that?
I think he was attempting, I think with failing to move in advance of trial, he was attempting a technique of trial by surprise, which worked in part because if
But he can't, you can't disregard the rules in order to attempt to do something differently.
well, he probably should have filed it in advance, but if he had filed it in advance and the ruling had been that this is voluntary, the Commonwealth also would have had it brought to its attention that he didn't have the Miranda card, and that would have been cured. So he would have lost
Yes,
that.
I mean, was he in violation of the rule? Was the defense counsel in violation?
Well, yes, he's in violation of Rule 15, but, I mean, he still had the humane practice option of raising it at trial. Because
Okay.
I recognize
Okay.
that it is certainly better practice to proceed with pretrial motions pursuant to
But
Rule
the bottom
15.
line is you're saying, no, he didn't violate I mean, he may have violated the motion to suppress, but he could hold his fire under...
He wasn't losing a substantive right of his client in this particular incident because he always had the option of raising humane practice under Tavares.
Yeah, but he in his motion during the course of the trial, he was also trying to raise a classic motion to suppress for failure to give Miranda, wasn't he?
Yes.
So
And
that should have been raised before trial.
that should have been raised before trial, Your Honor. It really should have been. But there's no prejudice from that because the judge heard it and, in fact, allowed it. So he did gain some advantage from doing it in
Well,
that
he
format.
did and he didn't. He allowed it, and then Justice Graney...
And then Justice Graney reversed the voluntariness,
Yeah.
which the defendant would have had notice of had it been fully litigated before trial.
No, but did the jury get a voluntariness instruction in this case?
I believe they got the humane practice instruction, yes.
Okay.
Yes.
Going back to the phone records, I don't want
Yes.
to beat a dead horse, but when the defendant testified on direct examination, did counsel use the phone records in some respect?
He attempted to. He was precluded from doing so by the judge, I believe. That's my recollection of it. The judge said, it's hearsay, it's hearsay, it's hearsay, essentially get it out of the courtroom.
So he wasn't permitted to say, do you know what the complainant's phone number is?
He was permitted to identify his own phone number from the records, using it to refresh his recollection. The judge said you can refresh anyone's recollection with a banana if you want. And then he said that's hearsay.
Okay.
And that was
I'll have to look
that.
at it.
That's the discussion on the phone records.
I actually don't think that's a fair statement of our evidentiary rules.
It may
Irving
not
Younger.
be. It is an
know
accurate
it's
quote of the
Irving
trial
Younger.
judge. But the trial judge said banana. So, finally, the witness that the defendant called would have been no help to the case. She said that she's heard normal conversational tones the whole time, which I would point out is inconsistent with both versions of the intercourse, both the good version with the moaning and the bad version with the no, no, no. So that wouldn't have been helpful to the case. If there are no further questions, the Commonwealth would rest on its brief.
Thank you.